thank you so much for joining me, everyone that is here. My name is Attorney LaConnie Murray. I am the small business attorney helping clients throughout the United States with trademarks, copyright, and business development solutions. Today, Ask Me Thursday is a great one, as we just discussed. We're going to talk about knowing the lingo. Okay, so you have this brand that you're building and you want to protect, because you are not just having a business for yourself. You have a business and you have great plans for your business. You want to have a business that's going to leave a legacy for your family. You want to create generational wealth. So when it comes to protecting your brand, what I want you to do is start with knowing the lingo. Some people use trademarks, service marks, trade secrets, copyrights. They use them all interchangeably. But they're not. They're not the same thing. And this is what you should know. So take your pen and paper out, and we're going to get started with the first one, okay? The first one we're going to talk about is a trademark, because we talk about that all the time on here. So we're just going to go ahead and get that one out there early. Trademark protects brand identifiers, helps consumers readily identify the source of a good. So a good would be, an example, my headphones is a good. It's a product. It's something that someone can hold. That is a good. And that's what trademarks protect. In common law, you'll see the symbol TM. Whenever you see a TM, that's the common law signal for trademark, meaning that it hasn't been registered yet, but someone's letting you know that this is their trademark to identify their good. Okay, so you have the first one, trademark. The second word, and I promise you that I will not give you a vocabulary test at the end. Well, I might. I don't know. Don't hold me to that. Okay, so the second one is a service mark. A service mark. And people interchange trademark and service mark. I do it because I know that's what you guys are used to it, but we're gonna do better. I have a motto with my 30 days to launch is when you know better, you do better. And when you do better, you grow better. So right now, we're going to know better so that you guys can start doing better and then eventually grow better. So the next mark is service mark, or the next word is service mark. And just like a trademark, it helps consumers readily identify the source, but this time they're going to be able to identify the source of a service. So for me, my office, Off the Mark, has a service mark. So anytime you see the initials SM next to something, you're like, man, what is that? That is identifying the source of a service. And that also means that it's not registered, just like the TM does. At the end of the day, though, once you get those marks registered, that trademark or that service mark, they both end up with the same R to show registration. All right, this is some good stuff. Definitely let me know below. You can hit the like button. You can hit the heart button. So definitely let me know. So the next one we want to talk about is a copyright. A copyright. People call me and they say I need to get a copyright for my business, but what they really mean is they need a trademark or a service mark. Trademarks and copyrights are both intellectual property, but they protect two different things, or they offer two different types of protections. Okay, sometimes they do overlap, but they offer two types of protection. So a copyright is an original, or protects original works or authorship, meaning someone who created something out of their own mind, whether it's art, whether it's music, whether it's sometimes jewelry design. In the United States, not so much fashion design. Hopefully they're working on that, but it's an original work. So when someone calls me saying that they want to get a copyright, but what they really want to do is protect their trade name, I know that that's a trademark. But now you know that unless you're talking about protecting your logo or protecting the content of your digital courses or protecting your book, when you're talking about those things are copyrights. All right, so we talked about trademarks, we talked about service marks, we talked about copyrights. The next thing I want you to talk about, which I probably should have did it before, but it's called trade dress. A trade dress. And when we talk about trademarks and we talk about protecting your brands, I always tell you to think outside of the box. So trade dress, when you're thinking about protecting your packaging, the thing that your product is put in, that's talking about trade dress. So a few months ago, we talked about Pepperidge Farm, how they had a suit against Trader Joe's for mimicking the the style of their bag. Well, the style of that bag is protected under trade dress. It's a form of trademark, but it's called a trade dress because it's not protecting an actual mark. It's protecting the packaging, the dress of it. Okay, so trade dress. So if you want to, which I highly recommend that if your business is selling products, that you get creative with your trade dress and create and come up with the concept of brand that helps consumers readily be able to tell your goods from someone else. Stand out, you know. So we have trade dress, copyright, service mark, trademark. The last thing I want to leave you with is trade secret. It's a trade secret because everything cannot be registered, and everything should not be registered, because one thing you have to realize is when you register this stuff, it's on federal websites. So if you have a source or something that is helping you take that slight edge over your competitors, but if they got their hands on it, you would lose that edge. More than likely, that's a trade secret, and you don't want to register your trade secrets anywhere. That's stuff that you need to keep with you. You need to keep it under lock and key. You need to make sure that as few people as possible know this stuff, until one, it could be protected, or two, if it can't get out, then it just can't get out. So what I mean by that is, when it can be protected, a lot of times we have these great ideas. But we haven't acted on them yet. So if we haven't acted on them yet, they can't be protected. So whether it's a great idea for a book, even though the book itself, once it's done, it can be protected because it's in a fixed form, while it's still in your head, it can't be protected. So rather than going and telling everybody and their mama about your great idea, keep it to yourself. Let it be your trade secret until you're ready to execute that idea. And some things like the Coca-Cola formula will never be out. That's always and forever going to be a trade secret. Okay? Great. So, with this information, did you guys learn something? Did you take notes? I hope you took notes, because I want you to be able to have better communication with whoever you're talking with about what it is you need, what it is you're protecting, what it is that they don't have the rights to. So when this information is important when you're drafting contracts. You know, you're talking about trademarks, but do you really mean copyrights? Do you really mean trade dresses? Do you really mean trade secrets? So this is information that is not just good for you to know, but good for you to put into practice. All right? So, like I said, if you have a question, thank you again for joining me. If you have a question, you know what to do. Hit me up. Hit me up on Facebook at Off the Mark IP Solutions. Hit me up in my email, which is askme@offthemarkipsolutions, and submit your questions and see if they make the cut, and we'll get to answer your question next week. All right?